This is Bill Hamilton at the University of Florida EDRM, eDiscovery Conference at the Levin College of Law in Gainesville, Florida in March of 2016. This is our 4th annual conference, and one of our distinguished panelists at this conference is Niloy Ray from Littler Mendelson, a member of its national eDiscovery practice. Welcome.
Thank you, nice to be here. Wonderful weather.
Wonderful weather. Niloy is going to be speaking on our panel talking about technology-assisted review, so I've been able to grab him a few moments before he goes on stage to share a few thoughts with us about the practice of eDiscovery, because you're in the trenches regularly.
I'm in the trenches regularly, and I think that one of the most crucial things that I've discovered or learned in these 5 years that I've been with Littler is that the trench starts a lot sooner in time than you thought the trench started.
And how soon is that?
As soon as you have, use the technical phrase, reasonable anticipation of litigation, because from that moment forward, especially for us as defense counsel, the onus is on us to immediately start defining what's within the scope of discovery, what's outside the scope of discovery, and most importantly, what is going to be really expensive and burdensome to collect, review, preserve, produce, etc. in discovery.
Now, so you've got to get to that by speaking with whom?
Right, so essentially, if you look at the federal rules, the rules tell you that you have to have what's called a 26F conference. So a 26F conference is where you sit down with the other side, with plaintiff's counsel, typically for us on the defense side, and you talk about the scope of discovery. You talk about those issues, among others, that you're then going to present to the court leading up to the Rule 16 conference, where you have a case management order schedule entered. So that's a whole mouthful of words. But what that means is you've got to come to that meet and confer, and that's the technical term of art we use, that 26F meet and confer with a large wealth of knowledge about your client's data systems, your client's information, your client's records, their paper. And what I see more often than not, Bill, is that people focus on that meet and confer as though that's where the discussion really gets going. Now, I think that there are 2 other meet and confers that happen that are a little bit more important even and more significant, particularly for us on the defense side. There's obviously going to be some level of disagreement with opposing counsel. That's the whole reason that we have these substantive meet and confers, because we're going to disagree on certain scopes of discovery. And that leads to a really important meet and confer with the judge, because to me, at the end of the day, I don't have to convince opposing counsel of anything. It'd be nice if I could convince them of everything and we could just get rid of the lawsuit. But I have to convince a judge and educate a judge more often than not on these systems and on this information and on this burden. And that meet and confer is really far more integral to the resolution of the dispute, because that's where it's going to end up. But to get there, to that 3rd meet and confer, and before the 2nd one with opposing counsel, you have to have a meet and confer that I dread the most, frankly, and it's the one where you have the least agency, the most lack of clarity, the most lack of information, and that's the meet and confer that you have with your own client. Whether it's a new client or a client whom you haven't litigated for in a couple of years, their data map or where they store their information, their entire business process might well have changed. And that's the first thing. That's why, going back to your idea of being in the trenches and trench warfare, that's where the trench starts. As soon as the complaint comes in or the allegations come in and you understand what this case might be about, you have to have that ongoing meet and confer process with your client to figure out, what do you have at the end of the day?
Yeah.
And you look at the new federal rules, you realize that they're putting more and more of that onus now on defense counsel and on defendants to respond to discovery and to specify, look, tell us what you're going to produce, when you're going to produce it by, even if you haven't yet gotten your arms around all of that information.
Right, so meeting with a client is an initial challenge, and I agree with you, because the rules are not defined and you've got to get the client's attention, and typically the client is abused by the process because no client believes they should have been sued for most items. The other issue that I ran into as eDiscovery became more and more important in my practice was a more upfront loaded cost that didn't fit many of the budget cycles of the client. So if you've got a quarterly cycle and then you have a case come in and there's a spike because your attorney's got to come in and spend a lot of time preparing for the Rule 26F conference, getting to know the data, sometimes that can rub wrong, or not rub wrong, but can be resisted by the clients who want to sometimes drag out the costs in a more managed way. Can you give us any tips on how to handle clients in that situation?
Well, so the first thing that I'd say is you have to educate the client on what the implications of not making decisions early on are going to be, because there are always cost ramifications down the road. Clients who, for instance, will take a preserve everything or a broad preservation approach will incur the costs of that broad preservation. Or there might be the risk of sanction if you don't immediately get your arms around what is out there and therefore start losing relevant information, whether it's ephemeral data, whether it's instant messaging, custodians who are being turned over and who are leaving and their data getting lost. So there's a certain way of sort of sketching out the parade of horribles, if you will, that might occur, and relying on your experience and expertise in that matter to say, this is a likelihood something like this might happen. The other thing that we do with clients is to explain to them that we're actually being proactive here, even though that's not a real word, but I'll say it. We're being proactive. And if it's a question of cost, getting this information early on and documenting it allows us to reuse and repurpose it if there's multiple litigations for them. If they've already done this work with another law firm in another lawsuit, they could certainly turn over that information and we can go through that. But documenting what you've learned so that there's no loss of that knowledge probably helps limit the costs. I'll give you an example. I'm dealing with a class action right now, and what I've done as part of that class action is gone through several hundred pages of notes taken by my colleagues in a class action with that same client 3 years ago. A good way to shortcut that whole process and actually not to have a meet and confer with the client necessarily, but just read the wealth of information that was collected. But at the end of the day, I don't think there's any way of getting away from getting that knowledge. And no one's in the business of litigation except us. I guess most businesses are in the business of business.
Right.
But this is a part of their cost, and if we can be predictable about it, whether it's with fee structures or with budgets, and be active about it and start early, then we can actually spread that cost out over several more months than if we backload it, which would be the alternative.
This is Bill Hamilton at the University of Florida eDiscovery Conference. I'd like to thank my guest, Niloy Ray from Littler Mendelson, and welcome to our conference, and thank you for joining us this year.
Absolutely. Good to be here.